there's two big buckets of potential discrimination claims that the EEOC and state agencies are concerned about. Disparate treatment, oversimplified, that's intentional discrimination, and disparate impact, that's a neutral policy or practice that disproportionately impacts one group or another. What the EEOC is really concerned about with technology solutions used in the workplace is disparate impact. The EEOC thinks that as we utilize these tools, because they are developing really, really quickly, that there is a real potential that they could be utilized unintentionally in a way that harms one group or another. And so the EEOC came out with some guidance almost exactly a month ago. I think it was like May 18th of 2023, talking about under Title VII, which is sort of the principal anti-discrimination law that covers things like race and gender discrimination. The EEOC identified for employers in technical assistance guidance, which isn't binding, but ignore it at your own peril, that this kind of technology can create really serious disparate impact risks. And they gave some recommendations about guardrails that employers should put in place from the EEOC's perspective to mitigate that risk. The principal one of those guardrails is the EEOC is telling employers, if you're using this kind of technology in the workplace to impact employees in any kind of decision-making fashion, you should be doing assessments, both before you implement it and on an ongoing basis after implementation. And the EEOC is also telling employers, look, we know that you're not usually developing this technology in-house, you're getting it from a third-party vendor. We get that. You're still probably going to be on the hook. If you're using this technology, even if you didn't develop it, somebody else bought it from them, and even if they tell you there's no disparate impact, which may happen, you're still on the hook because you're the employer and you're responsible for making sure that employees are treated fairly in the workplace.
So are they talking primarily about like applicant tracking technologies and or pre-screening tools?
They gave a list of the types of uses of this sort of technology that they're commonly seeing in the workplace. And sure, resume screeners are a big one, but they were even talking about things as simple as chatbots in the workplace. Really anything that you're using as an employer that has an impact on employees from a decision-making or from a job performance perspective. They even talked about monitoring software that employers might be using. All of that is in the umbrella of what the EEOC calls artificial intelligence, technology, and software. They're concerned about all of it. And I think we talked in our last session about prior guidance that the EEOC issued about a year ago related to the Americans with Disabilities Act, because that's another big concern they have, that employees aren't aware of what this technology is. They don't know how employers are using it, and they don't have the opportunity to request a reasonable accommodation so that they can perform their job functions or have the same opportunities as everybody else as this technology is used in the workplace.